Some people argue that the Supreme Court of Canada has more influence on day-to-day living than any government in Canada. For instance, there was no right to strike in Canada until a Supreme Court justice said, it's time that we give this right to strike constitutional benediction, and there it is. No legislator passed it. Gary Clewley is a noted criminal defense lawyer in Toronto. He's a lawyer in New York State. He joins me right now because I want to talk to you about judge-made law, not just in defense law, but it seems to be permeating throughout our society that the Supreme Court decisions are there and they're imposing them without legislation.
That horse left the barn a long time ago.
In
this country?
1982?
Oh, I would say by the 90s,
yeah.
When the wind really got into the sails. That ship's been barreling along the sea now for at least 2 decades.
Most people don't know about it, though, because they complain about certain things and they say, well, they don't know that. It's not the federal government, it's the Supreme Court.
Well, who's against rights? Nobody. It's like being against...
You are if the rights are interfering with somebody else's rights.
I agree, but the issue is who ought to make them? They didn't.
The people that we elect, not the people that the Prime Minister appoints.
Exactly right, because the Supreme Court didn't make the charter.
That's true.
So what happened to remember the horse and the wagon? When did they get reversed?
No, but when? As in the right to strike.
Well,
a judge who used to be the head of the Ontario Labour Relations Board,
right?
Pro-Labor said it's about time we do this. Us justices do this. Nothing to do with somebody elected.
It was never about time, because if you're not, because they don't participate in the debate in the way that allows the rest of us to get our say. That's what Parliament was designed for.
Right.
They're the offense. These guys are playing defense. That's what they were invented for.
Yes, but they aren't now.
No, they're playing offense. No, they threw that off a long time ago. I mean, are you kidding me? They're not. They're throwing the ball and devising the passes.
So really, I mean, if somebody is objecting to a way that certain our rights and liberties are being interpreted or being, enforced in Canada, I mean, what should we do about it? Should the MPPs grab it back?
No, some governments are doing something about it. It's called the notwithstanding clause, and that's a problem, right? Because that seems like they're against the rights, right? I mean, Alberta's talking about it, Quebec's done it. Mr. Ford threatened to do it not only recently.
Yeah, but people understand that people who speak English in Quebec should have the right to speak English. Well,
no, I get it. But my point is that the fact that you would go to the notwithstanding clause means you don't have the confidence in the courts to stay out in their lane. That's the problem. Nobody has any problem with them driving in their lane. We just don't want them crossing into ours.
So are you anticipating that more and more legislative bodies will use the notwithstanding clause?
I do.
To get their way?
No question about it.
And sometimes they'll be very popular.
Sometimes it'll be very popular, but it can also be very anti-democratic.
Well, it's a mess, Gary Clewley, but thank you very much. 3 minutes. A number of people tell me I am no longer a liberal. I am a liberal, and this station is not about liberal or conservative politics, nor about left or right politics. It is about efficient government and honest government and getting the best way to help people in Canada. That is why we are not paid by the government, and that is why we're looking for your support. Press subscribe, and if you can make a donation, we appreciate it.